Thank you for joining us for another one of our videos. We are now in the middle of doing, or we're at the beginning of doing, a 12-part video of what Amazon sellers need to know about intellectual property rights and what Amazon sellers need to know about intellectual property rights suspensions and how to get out of them and how to deal with them. This is David Miller. He's one of the associate attorneys with our firm, and we're going to be talking to you today about the basics. We're going to start with basic trademark law for Amazon sellers. So David, if you can, tell sellers what they need to know about basic trademark law in the United States.
Sure. So essentially what a trademark is, it's a name, a logo, a word that identifies a brand. So basically when you see, the Nike check mark on any product, you see the, the M for McDonald's, you know exactly what company that is and what type of products they sell, and that's essentially what a trademark is. And basically the standard of when someone's infringing is when there's consumer confusion as to what product or what brand products we're buying. Okay,
now the application for a trademark is relatively easy. In fact, we help sellers do it themselves all the time.
Yes, we do.
You do it online at USPTO.gov. USPTO.gov, that's the United States Patent and Trademark Office, and you fill in space by space by space what you're trying to apply for to get a trademark protection. It doesn't cost a lot of money, it doesn't take a lot of time, and if a seller tries to do it themselves and there's a problem, what happens?
Generally what would happen is you get what is called an office action. That's basically what, something you have to respond to. There's a lot of different things that could happen in the office action. We have clients that come to us, asking for help. Sometimes they want us to file the trademark, for them initially. But basically we tell people that it's something that most people can do on their own, but a lot of people aren't comfortable or aren't sure, and they want it done by the best or by a law firm, so we're always here to help.
So just a couple of days ago I was at an Amazon sellers event, and lawyers don't always agree. In fact, David and I don't even always agree. And the lawyers were telling people that they shouldn't try and file for their own trademark themselves because it creates problems. I disagree. I think sellers should try and do it themselves. I believe in teaching sellers how to handle things themselves. And if you do have a problem, if they do get an office action, it will slow it down a little bit, but not tremendously so. It's still going to take somewhere 6 months to a year to actually get your mark approved. So we are fully in favor of Amazon sellers trying to do as much as they can themselves. So that's the basic trademark law. Now, trademark is different than copyright. Copyright, you don't have to file anything. When it comes to copyright law, it really pertains to images or pictures and verbiage. So, David, if someone takes their pictures themselves and they write a description of a product, do they have immediate copyright protection?
When you take pictures yourself and you post them on your Amazon listings, generally you're protected by copyright yourself. Now, that doesn't, essentially with, regarding Amazon in general, a lot of people wonder when they join a listing, are they violating any type of copyright law? And the answer, in short, is no. The reason is Amazon grants you the perpetual license to join those listings. Now, that's kind of unique compared to how copyright is just generally, but essentially when you take your own pictures, you're protected. If you take someone else's pictures, say from another website, and you create a listing, you would be violating copyright law.
Now, copyright is all about the creative nature, the creative process. So as soon as you create it and it's in some type of media that's firm, that's not going to disappear, you own it. Like scents, the way a perfume smells is not something that can be copyright because it's not captured in any type of media. But as soon as you take that photograph, as soon as you write that listing, as soon as you create that pamphlet, you own it. The ability to enforce it in court may depend on whether you actually file with the Copyright Office or not, but in terms of you owning it and you using it either as a sword against other sellers or a shield to protect yourself, okay, that's the basics of copyright law. As soon as it's created, the picture is snapped, the verbiage is written down,
correct,
you have copyright protection. Now, patent law is a little bit more complex. Patent law, there are two different types of patents around the world. One is a design patent and one is a utility patent, and in Europe they call it a patent. So David, tell us basics about what a design patent is.
So design patents, first off, protect the appearance of a product. So whereas I'll get to both types, but basically design patent, for example, if you wanted to put a design patent on a toaster oven, say a Mickey Mouse toaster, That would be an example of a design patent. No one else would be able to create a Mickey Mouse toaster. Now, they're not as valuable as utility patents. In fact, I believe 90% of them are accepted, whereas for utility patents, 90% are rejected. Now, a utility patent protects the function of it, so that would be the actual toaster itself. Now, some people wondered, okay, so if you can patent, why are there so many different types of toasters today? The reason is because patents expire. So a utility patent is only good for 20 years, and then it goes in the public domain, and everyone is free to buy, sell, and manufacture them.
So if we break that down, design is how it looks. Okay, it's sort of the shape and the feel of it. Utility patent is how it functions, like with a toaster oven with the coils that actually take the bread and make it into toast. That's the mechanism, that's the utility of it all, and they're entirely different things. Design patents are weak, but they're much easier to obtain. They're also significantly cheaper to maintain. And if you see a product and you want to improve upon it, and the inventor of that has simply a design patent on it, you improve it, you add more pockets, you add more zippers, you add structure to it, you alter the appearance of it, you add buttons or screens, right. You're probably not violating that design patent anymore because it just affected how it looked and the basics of it. The utility of it, though, is an entirely different ballgame, but those patents expire. So if you have a product and you're watching it, you can check to see when a utility patent's going to expire, and design patents are fairly easy to get around. So those are the basics of United States patent law. Now, trade dress is something different, okay? Trade dress has to do with the look, feel, color, shape, texture, packaging. It's really the whole kit and caboodle of a product, and that makes trade dress. And trade dress never expires, and trade dress doesn't have to be filed. David, a good example of trade dress is the Beauty Blender sponge.
Right, or the Coca-Cola bottle, or...
Let's talk about the Coca-Cola bottle.
A goldfish, stuff like that.
Talk about the Coca-Cola bottle. Talk about the trade dress, how the Coca-Cola bottle never expires.
Right. Basically, it's just the shape of it, the way the appearance of it, the way it looks. Basically, you see that bottle, even without the logo on it, you know it's a Coca-Cola bottle. That's essentially what trade dress is. It's a type of trademark, and a lot of people, I don't think, realize that. They see them as two different categories, but it is a specific type of trade dress. And it's trademark, sorry.
It's the shape of the bottle, the texture of the bottle, that around the world, you see that bottle, you know it's Coca-Cola, and that's protected, and it's protected, indefinitely. Okay, the last of the 5 topics we wanted to talk about in this basic overview of intellectual property law is the first sale doctrine. The first sale doctrine only exists in the United States. It doesn't exist in Europe. It's purely something created in America under US law. And what it basically says is that you can buy and sell anything you want. You don't need the manufacturer's permission, but when you resell it and you deliver it to a consumer, it can't have any material differences in what the consumer receives. And there are a lot of exceptions. There are a lot of things that are materially different that you might not expect. David, why don't you talk a little bit about things that make a product materially different that brands use every day to knock off unauthorized sellers?
So one that we actually use a lot, it's probably the most popular one, is warranties. So essentially when you manufacture a product and you create a warranty with the product. Now when you sell it on Amazon, and say there are other Amazon sellers who sell the same product, maybe it's not counterfeit, maybe they've bought it and they've resold authentic products, but their products do not include the warranty, the original manufacturer's warranty. That would be considered a material difference, and you would not be protected by the first sale doctrine. Other examples include exclusive packaging, lack of quality controls. Those are some of the most common examples we use.
Now, as a seller, you need to know both sides of the fence. If you're a private label seller, you of course want to know how you can protect your product from hijackers. And if you're a third-party seller and you're buying products from a distributor or off the back of a truck, we don't really care where you get them from. You want to know which complaints are valid and which complaints you can defeat by simply asserting a first sale doctrine. So warranties that just give money back do not cut it, because money is homogenous. It's like milk. Anybody can give back money, and $1 is $1. Warranties that say that the product's going to be refitted or fixed the original specifications in the original factory back where it was manufactured, then a third-party seller can't match that because you don't have access to that factory. So each product has its own permutations as to what will either keep it within the first sale doctrine, meaning anybody could sell it, and what takes it outside the first sale doctrine. And during these dozens, it's probably going to go to 20 different videos. We're going to have one specifically and solely about the first sale doctrine. But for the basics of intellectual property law in this series, those are the top 5 issues we wanted to go over with you. Basic trademark law, basic copyright law, basic patent law, basic trade dress, and we want you to have an understanding of the first sale doctrine, how you can defend yourself from baseless claims, and also if you're a private label seller, how you can use different factors to take your product outside the first sale doctrine. So David, thank you very much.
Thank you.
What we're going to do is I'm probably going to sit down and do these videos with the various associates that we have here, and I'll shoot some by myself. And if you have any questions, please email me, cj@Amazon Sellers Lawyer, and we're trying to also respond to your questions during these videos to pay it forward, provide sellers with the information you need to know so you can continue to succeed on Amazon and on all online platforms. So thank you very much.
Thank you.